This is the brief on Philippine foreign agent laws. Two historical laws from 1946 and 1979 serve as the strict rulebook for tracking foreign influence, showing us exactly how the Philippines protects its politics from hidden agendas. First, these laws demand radical transparency. Under the 1979 Act, if you're doing political consulting, PR, or propaganda for a foreign principal, you've got to register with the Ministry of Justice within 30 days. You also have to provide sworn updates every 6 months. And get this, it is all completely open to public scrutiny. It's basically forcing anyone pushing a foreign agenda to wear a permanent public name tag. Second, there are strict financial firewalls in domestic politics. Foreign agents are legally banned from tying their pay to political success, so absolutely no sketchy contingency fees. They're also strictly prohibited from throwing cash at local campaigns or conventions, and public officials can't act as foreign agents unless explicitly certified for the national interest. So, what does this actually achieve? Well, it actively cuts off the financial pipeline from foreign powers directly into local elections. Finally, they protect the real while punishing the fake. The 1946 Act ensures legitimate diplomats are safe, making any warrants to arrest them or seize their goods legally void. But if you're an impersonator wearing a foreign uniform just to deceive people, you're going to face severe consequences. Think of it as a VIP diplomatic protection program combined with harsh stolen valor penalties for fraudsters. Ultimately, these laws prove that when a nation's sovereignty is on the line, forcing hidden influencers out into the open is absolutely the best defense.
Welcome to this video on the boundary of influence, where we navigate the regulation of foreign agency, diplomatic immunity, and political influence in the Philippines. We will examine the framework established by RA number 75 and BPBLG 39. We have two core policy approaches. RA number 75 offers absolute protection to shield duly accredited foreign diplomatic agents from local interference, providing immunity from arrest, seizure, and writs. BPBLG 39 mandates transparency to regulate and illuminate the political activities of non-diplomatic foreign agents through rigorous registration and disclosure. This diagnostic flow helps determine the applicable regime. If you are a foreign national or representing a foreign principal, you must first check if you are a diplomat, UN official, or foreign press member. If so, RA number 75 may apply. Otherwise, if you are not strictly limited to private or legal pursuits, and you attempt to influence Philippine government policy or public opinion, you are a regulated agent under BPBLG 39. The regime matrix outlines the differences. RA number 75 protects accredited diplomats and is governed by the Department of Foreign Affairs, focusing on absolute sovereign protection. BPBLG 39 regulates political consultants and PR counsel, is governed by the Ministry of Justice, and requires registration and disclosure under strict deadlines. Domain I covers the sovereign shield, diplomatic immunity under Republic Act number 75. This act penalizes activities that impair the proper observance of immunities, rights, and privileges granted to duly accredited foreign diplomatic and consular agents. RA 75 provides immunity from prosecution, distraint, seizure, arrest, or imprisonment. The protection extends to domestic servants of ambassadors or ministers, provided their name is registered with the Department of Foreign Affairs and the Chief of Police. The reciprocity engine is crucial. Diplomatic immunity in the Philippines is entirely conditional on mirror image treatment. If a foreign state curtails the rights of Philippine envoys, their diplomats in the Philippines immediately lose the protection of RA number 75. Offenses against the state under RA number 75 include the impostor for falsely assuming diplomatic character, the unauthorized agent for acting without prior registration, and the assailant and the counterfeit for unauthorized wearing of foreign regalia or violence against an ambassador/minister. Penalties include fines and imprisonment. Domain 2, the illuminated agent, focuses on regulation and transparency under Batas Pambansa BLG 39. This regime requires foreign agents to register and disclose their political activities so that the government and the people are informed. A foreign agent acts on behalf of a foreign principal. This includes political consultants, public relations counsel, publicity agents, and information representatives. Registration is mandatory if they engage in, quote, political activity, defined as any effort to influence Philippine government policy or the public. BP-BLG 39 offers safe harbors or exemptions for specific activities, including duly accredited diplomats, non-political commerce, bona fide charitable or academic pursuits, legitimate foreign press functions, and legal counsel representation. However, the legal counsel exemption does not cover attempts to influence officials outside ordinary official business, such as shadow lobbying. The compliance lifecycle has three main stages. Initiation requires filing an initial sworn statement within 10 days of becoming a foreign agent, disclosing contracts and contributions. The semi-annual audit requires a supplementary statement every 6 months. Finally, the Ministry of Justice transmits copies of all records for national policy review in the data pipeline. The propaganda funnel outlines the rules for transmitting political propaganda. Step 2 requires mandatory labeling. The material must be prefaced by a statement that the individual is a registered foreign agent. Step 3 enforces the 48-hour window. The agent must file 2 copies of the propaganda with the Ministry of Justice detailing the transmittal, not later than 48 hours after the beginning of the transmittal. BPBLG 39 establishes 3 red lines of influence. Red Line 1 forbids contingency contracts, where compensation is dependent on the success of a political activity. Red Line 2 prohibits agents from making or receiving campaign contributions. Red Line 3 makes it unlawful for public officers or employees to act as foreign agents, except under specific national interest certifications. In synthesis, RA 75 focuses on preventing assaulting sovereignty by protecting diplomats, with penalties of up to P5,000 fine and 5 years imprisonment. BP 39 aims to prevent evading transparency, with penalties up to P10,000 fine and 5 years imprisonment. The ultimate consequence for a foreigner breaking either law is deportation.
So, when you have foreign representatives operating in the Philippines, what are the rules of the game? Well, it turns out it's not just one rulebook, but 2, and they're very, very different. Today, we're going to break down a pair of laws that draw a really critical line. One is all about managing foreign influence, and the other is about protecting foreign diplomats. Let's get into it.
Here's the roadmap for today. We'll kick things off by looking at the core goals of each law. Then we'll figure out who exactly is a foreign agent. We'll cover the rules they have to play by and then contrast that with the special protections given to diplomats. After that, we'll see what happens when you break those rules. And finally, we'll wrap it all up by talking about why this whole balancing act matters so much.
All right, so at the very heart of this are 2 different pieces of law, passed decades apart, that handle foreign presence in completely different ways. You can really think of it as a story of transparency versus protection. And the difference is just crystal clear right from the start. The Foreign Agents Act from 1979, it's basically a giant spotlight. Its whole purpose is to make any political activity from abroad totally transparent. But then you have the Diplomatic Protection Act from way back in 1946. That one's not a spotlight, it's a shield. It's designed to guarantee the safety and security of official diplomats. So, 2 very different missions.
Okay, so let's zoom in on that first law, the one from '79. To really get how it works, we have to get the definitions right. Because, the law is super specific about who it's actually targeting.
First up, you've got the foreign principal. The easiest way to think of this, it's the boss. The law says this could be a foreign government, a political party, or even a company that's controlled by foreign interests. They're the ones giving the orders. And if the principal is the boss, then the foreign agent is the employee. This is the person, or even a whole group, that's acting on behalf of that foreign boss. The law actually lists roles like political consultant or PR counsel. Basically, if you're in the Philippines doing political type work for a foreign entity, this definition could be talking about you.
And here's the most important part, the mission itself. The law calls this political activity. And we're not talking about just any kind of work. It's specifically about trying to influence or persuade government officials or the public on policy matters. It's that act of trying to shape opinions that sets the whole law in motion.
But the law is also smart enough to make some really important exceptions. Accredited diplomats and their staff, they're not considered foreign agents. Same goes for officials from places like the UN or legitimate foreign journalists who were just doing their job. And this distinction is absolutely crucial because it separates official diplomacy and news reporting from the kind of targeted foreign-directed political activity this law is all about.
So, we know who a foreign agent is. Now what? What does the law actually make them do? Well, the entire point of this 1979 Act really comes down to one thing: transparency. And you get that transparency through registration.
The process itself is pretty straightforward. You've got 10 days from when you become an agent to file a statement. And this isn't just about signing a form. You have to lay it all out. Who you are, who you work for, that's your foreign principal. And you have to hand over a copy of your contract, including how much you're getting paid. And maybe most importantly, you have to give a detailed breakdown of exactly what you'll be doing.
And get this, these files aren't locked away in some government basement. The law specifically says they are public records. Anyone can go and look at them. And that right there is the whole point. The idea is that if someone is going to try and influence Philippine policy for a foreign power, then the Filipino people have a right to know all about it.
Okay, let's switch gears completely. We're moving away from the spotlight of transparency and picking up the shield of protection. The Diplomatic Protection Act of 1946 has a totally different goal. It's all about making sure official diplomats can do their jobs safely, following international rules. And this act does not mess around. It gets very specific about what is absolutely off limits. You can't pretend to be a foreign official to trick someone. You can't illegally arrest a diplomat or take their stuff. And, most fundamentally, any kind of violence, assaulting, hitting, or wounding an ambassador is a very serious crime under this law. It's all about protecting them and the important role they play. Now, here's a really fascinating detail. These protections aren't just automatic. There's a reciprocity clause. What does that mean? It means this shield only works if the diplomat's home country gives the same kind of legal protection to Filipino diplomats over there. It's a two-way street, which makes perfect sense. It's all about mutual respect in international relations. Okay, so we've got one law that demands you tell everyone what you're doing, and another that promises to keep you safe. What happens when someone breaks the rules of either one? Well, the consequences are just as different as the laws themselves. Let's just put the penalties side by side. Under the 1946 Diplomatic Act, hurting a diplomat could land you in prison for up to 3 years. Impersonating one could get you 5. Now look at the Foreign Agents Act from '79. It's all about making you register. If you don't, or if you lie on your forms, you could be looking at up to 5 years and a pretty hefty fine. You can see how the penalties really match the purpose of each law. But wait, there's more. Even if you are a registered agent, there's still a list of things you absolutely cannot do. For one, you can't make political contributions. Your pay also can't depend on whether you succeed politically. That prevents, a sort of bounty on influence. And whenever you talk to the government, you have to say, hey, I'm a registered agent. These rules are all there to keep influence from crossing the line into outright corruption. So, when you put this all together, what are we really looking at? What you're seeing is a nation trying to perform this incredibly delicate balancing act, one that's absolutely essential for both its own security and its relationships with the rest of the world. And really, this is the main thing to remember. The Foreign Agents Act is the spotlight. It's there to make sure that any effort to influence policy from the outside happens out in the open, protecting national interests. And the Diplomatic Protection Act, that's the shield, holding up the global rules that let countries talk and work together safely. You absolutely need both to operate in the world today. So I'll leave you with this question to think about. These laws give us a legal framework, but they don't solve the core issue. In this super interconnected world we live in, how does a country use that spotlight of transparency to protect itself without dimming the crucial work that happens under the shield of diplomacy? Finding that line between a partnership and just plain influence, well, that's not something you decide once. It's a constant negotiation that every country, including the Philippines, has to navigate every single day.
Have you ever wondered, who is actually behind the political messaging you consume on a daily basis?
Yeah, it's a huge question.
Right. I mean, think about it for a second. You're reading this fiery op-ed about trade tariffs, or maybe you see a slick social media campaign advocating for some new environmental policy.
Or even just hearing a pundit on a morning news show.
Exactly. Who is pulling the strings there? And more importantly, if a foreign government is secretly bankrolling that message to manipulate your country's domestic policy, what does a government actually have to do to force those hidden influencers out of the shadows?
It is, it's really the ultimate question of modern sovereignty. I mean, we usually think of national defense in these highly visible terms, right?
Like borders and military.
Yeah, exactly. We imagine passport control, military bases, concrete walls. You look at a map and you can trace a bold black line that says, here is where our jurisdiction begins. But when you step into the realm of public relations and soft power, covert influence, that physical border wall is completely, utterly useless. The defensive landscape is invisible.
Which is wild. So welcome to this deep dive. Today our mission is to explore that exact invisible machinery of foreign influence.
It's going to be a fascinating one.
It really is. We're going to unpack how a nation legally defines the boundary between, a welcomed, highly visible foreign diplomat and a shadowy, unregistered foreign agent. We're looking at the architecture of policing the unseen.
And to guide us through this, we have a really great stack of source materials today.
Yeah, we're anchoring on two specific laws that serve as these time capsules, I guess, for how a government tries to protect itself from foreign interference.
And the contrast between these two laws is what makes this exploration so compelling. First, we're looking at Republic Act number 75.
Right, from October 1946.
Exactly. This is a law deeply rooted in the physical world. It deals with the literal bodily protection of foreign diplomats and the severe penalization of anyone who tries to physically impersonate them.
And then our second source acts as this massive chronological and conceptual leap forward. We are jumping to the Foreign Agents Act of 1979.
This is a whole different beast.
Totally. It's this comprehensive piece of legislation designed to regulate political propaganda, public relations, and foreign lobbying.
Yeah, when you lay these two laws side by side, you really witness the evolution of a nation's anxieties. I mean, the 1946 law is obsessed with physical imposters and literal arrests.
Yeah.
But the 1979 law, it shifts entirely into the psychological realm. It's an acknowledgement that the battleground is no longer just the embassy gates, right? It's the minds of the citizens.
Well, let's start with that 1946 mindset, because I don't think you can truly appreciate the complexity of regulating invisible influence until you understand how a country protects its highly visible foreign representatives.
That makes sense. You have to set the baseline.
Right. So, October 1946. The world is just catching its breath after the devastation of the Second World War. Manila is rebuilding.
Global alliances are constantly shifting.
Exactly. And the government passes Republic Act number 75. And right off the bat, I mean, the law lays down an incredibly heavy hammer regarding imposters.
It really does. It addresses a very specific, tangible threat. Section 1 of the Act states that if you falsely assume or pretend to be a diplomatic, consular, or any other official of a foreign government,
and you do it with the intent to defraud, right?
Right, with the intent to defraud, the state is going to come after you with everything it has.
We are talking about a fine of up to 5,000 pesos or imprisonment for up to 5 years or both.
And 5 years is a long time.
It is. And the text makes a point to say this is in addition to any other penalties that might be imposed under the revised penal code.
Let's ground that for a moment for the listener.
Yeah, please.
In 1946, 5,000 pesos is a staggering amount of money. And 5 years in a post-war prison is no joke.
No, absolutely not.
If you steal a watch while pretending to be a foreign consul, you get punished for the theft. Plus, you get this massive 5-year anvil dropped on your head just for the act of pretending.
Which makes sense on some level. But then you have to look at how the law treats a different kind of imposter.
Oh, the uniform section.
Yes, this is exactly what I wanted to ask about because there is a bizarre discrepancy here. Section 3 of that same 1946 law talks about wearing unauthorized uniforms.
Right.
It says that if you wear the naval, military, police, or official uniform of a foreign nation that the country is at peace with, and you do it with the intent to deceive, the penalty is, well, it's up to 200 pesos, or up to 6 months in prison.
It is an incredible contrast, isn't it?
I am struggling to understand the logic here. I mean, a 200 peso fine and 6 months for wearing a fake military uniform seems almost negligible compared to the 5,000 peso fine and 5 years in prison for acting like a fake diplomat.
It does seem backward at first glance.
Right. I mean, a military uniform inherently implies armed authority. It implies the threat of physical force. A diplomat is just, a person in a tailored suit.
A very nice suit, usually.
True. But why does the law treat the fake suit so much more harshly than the fake military uniform? Is this just a case of stolen valor being viewed as less dangerous?
It's not just about stolen valor, actually. It's a really brilliant calculation about systemic vulnerability. You have to consider what a person can actually accomplish with these respective disguises.
Okay, unpack that for me.
Imagine someone in 1946 puts on a fake foreign naval uniform. They walk into a bar, they might swindle some free drinks, maybe they intimidate a local merchant, or they might cause a minor public nuisance.
It's a petty crime, basically.
Exactly. It is deceitful, and it might cause some localized diplomatic embarrassment if the real foreign navy finds out. But the damage is contained to the people in that immediate physical space.
The damage is localized. Okay, I see where you're going.
Precisely. Now, look closely at the specific wording in Section 1 regarding the fake diplomat. The severe penalty applies when someone assumes the diplomatic role to demand or obtain from person or from said foreign government or the government of the Philippines any money, paper, document, or other thing of value.
Okay, paper, document, or other thing of value.
Yeah.
That implies something far beyond getting a free meal at a pub.
We are talking about the state apparatus itself. In the fragile post-war era, a person successfully acting as a fake diplomatic agent could walk into a government ministry and extract classified intelligence.
Oh, wow.
They could manipulate treaties, they could redirect massive disbursements of international reconstruction funds, they could trigger an international incident that fractures a vital alliance.
So the stakes are just infinitely higher.
A fake uniform deceives a citizen, but a fake diplomat deceives the sovereign state. Falsely acting as an official agent threatens the bedrock of national security in a way that wearing a fake sailor's hat simply does not.
That makes a lot of sense. The diplomat is the key holder. They operate in the back channels where the most sensitive decisions are made.
Exactly.
So the state builds a 5-year prison sentence around that role as a massive deterrent. You do not play games with the diplomatic channel.
And because that channel is so sensitive, the people who are actually authorized to use it, like the legitimate, recognized ambassadors, are granted a level of protection that defies standard legal logic.
Yeah, if you are a real diplomat, the 1946 law wraps you in a legal force field.
Let's talk about that force field, because the concept of diplomatic immunity is something you hear about in spy movies all the time.
But reading the actual text of how it works is kind of jarring, honestly. Section 4 of Republic Act 75 outlines this immunity, and the language is just absolute.
The text states that any writ or process sued out or prosecuted in any court, whereby the person of any ambassador or public minister is arrested or imprisoned, or their goods or chattels are distrained, seized, or attached, shall be deemed void.
Okay, I want to pause and translate some of that legalese for you listening, because goods or chattels distrained sounds like medieval English.
It effectively is medieval English, honestly.
Right, so in plain terms, a chattel is just an item of personal property.
Right.
A car, a bank account, a piece of furniture.
And distrained or seized means taken by legal authority, usually to pay off a debt.
So if I understand this correctly, let's say a recognized foreign ambassador buys a fleet of expensive vehicles from a local dealership and then simply refuses to pay the bill.
A classic hypothetical scenario.
If the dealership goes to a local judge and the judge signs a legal order to repossess those cars, to seize those chattels, Section 4 says the judge's order is completely void. It legally does not exist.
The paper is effectively blank. You cannot arrest the ambassador for the theft, and you cannot legally repossess the cars.
But it gets even wilder than that. The law doesn't just say the warrant is void. It turns the legal system into a weapon against anyone who tries to enforce that warrant.
Yes, Section 4 says that every person by whom that writ is obtained or prosecuted faces punishment.
Including the party suing, their attorney, and every officer concerned in executing it.
Up to 3 years in prison, and a fine of up to 200 pesos.
Wait, let me make sure I'm painting this picture correctly for everyone. If a local police officer is handed a warrant by a judge, and that officer knocks on the ambassador's door to execute it, the police officer goes to prison for 3 years.
Yes, the person who filed the complaint, the lawyer who drafted it, and the police officer executing the arrest are all criminally liable for simply trying to subject a foreign diplomat to local jurisdiction.
That is mind-blowing.
And Section 6 extends this to physical violence. Assaulting, striking, wounding, or imprisoning a diplomat yields that same penalty, up to 3 years and 200 pesos, on top of whatever regular assault charges apply under the penal code.
It is an absolute impenetrable bubble. You cannot touch them, you cannot take their property, and you cannot even ask the legal system for permission to touch them without risking your own freedom.
It sounds like a recipe for absolute chaos.
It really does.
But it would only be chaos if it applied universally to everyone remotely connected to an embassy. The law is actually quite pragmatic here.
Oh, right, because they can't just hand out get-out-of-jail-free cards to everyone in the building.
Exactly. It recognizes that while the ambassador needs this ironclad protection to function, there have to be specific cracks in the armor.
Particularly when it comes to the people working for the ambassador.
Right. Section 5 outlines the exceptions. The law states that immunity from arrest and seizure also applies to the domestic or domestic servant of an ambassador.
But then it immediately pulls back that protection with some very specific conditions.
The first major condition is the pre-existing debt loophole. The immunity does not apply if the servant being sued is a citizen or inhabitant of the Philippines, and the legal process is founded upon a debt contracted before they entered into the diplomat service.
Which is incredibly smart. I mean, it stops the embassy from becoming a sanctuary for local debtors.
It prevents people from hiding.
Right, you can't rack up a mountain of gambling debt or default on a business loan and then suddenly avoid the consequences by getting a job sweeping the floors of the French embassy.
Your past financial obligations pierce the diplomatic shield.
But the second condition for domestic servants is perhaps the most fascinating administrative detail in the entire 1946 law, at least to me.
It is very unique.
A servant does not automatically get immunity just by virtue of employment. To activate the shield, a rigorous physical bureaucratic process must be followed.
I absolutely love this detail too.
For a domestic servant to be immune, their name must first be registered with the Department of Foreign Affairs. Then, the Secretary of Foreign Affairs has to physically transmit that name to the Chief of Police of the City of Manila.
And what does the Chief of Police have to do with it?
The law mandates that the Chief of Police must post that list in some public place in their office. All persons are legally allowed to resort to that list, look at the names, and take copies without paying any fee.
I want you to really visualize this because it is so wonderfully analog. Imagine it's 1947. You are a local tailor.
Okay, I'm a tailor.
A man comes into your shop, buys a dozen custom suits, and disappears without paying. You hire a lawyer, you are furious, you are ready to send the police to his house.
Naturally.
But before you can legally file the paperwork, you literally have to walk down to the Manila Police Headquarters, push through the double doors, find a physical wooden bulletin board tacked to a wall in a public corridor.
And run your finger down a typed list of names to see if this deadbeat happens to be the immune valet of a foreign minister.
It is physical public transparency. In an era before digital databases, the government had to create a physical bottleneck to prevent secret immunity.
If the name isn't pinned to that board in the police station, the police can and will arrest them.
The state is ensuring that the public has a way to know exactly who is operating outside the standard legal framework.
It's brilliant. But let me ask you this. Why does the Philippines offer this at all? Why surrender sovereignty like this?
It's a great question.
Why allow an ambassador to ignore local laws and throw your own police officers in jail for trying to enforce them?
That brings us to Section 7, which is really the cornerstone of this entire legal structure. None of this exists in a vacuum.
Not the voided warrants, not the protections for servants, not even the bulletin board.
None of it. It all hinges on the reciprocity clause.
Section 7. It says that the provisions of this act shall be applicable only in cases where the country of the diplomatic representative has provided for similar protection to the diplomatic representatives of the Philippines.
The operative word there is similar. The Philippines is making a highly conditional offer.
They are telling foreign nations, we will shield your ambassadors from our police, and we will criminally punish our own citizens for trying to sue them, but only if you provide the exact same legal fortress for our ambassadors in your capital city.
It's an international staring contest, a geopolitical game of, I'll scratch your back if you scratch mine.
Or, to put it more bluntly, it is mutually assured destruction of jurisdiction.
That's a perfect way to phrase it. International diplomacy is built on the reality that sovereignty is absolute. You cannot force another country to treat your representatives well.
You can only leverage how you treat theirs.
If a foreign nation decides to strip a Philippine ambassador of their immunity and arrest them, the reciprocity clause ensures that the foreign nation's ambassador in Manila instantly loses their shield as well.
So the entire system only works because everyone agrees to play by the exact same rules. Without reciprocity, the 1946 law collapses.
Completely.
Okay, so we have this intense physical legal framework established in the wake of World War II. Imposters are thrown in jail to protect state secrets. Real diplomats are protected by a conditional physical force field.
But there is a tiny, almost throwaway detail in Section 2 of this 1946 law that serves as the bridge to our second source today.
Section 2 briefly mentions the concept of an agent.
Right. It states that any person, other than a recognized diplomat or attaché, who acts in the country as an agent of a foreign government without prior notification to and registration with the Secretary of Foreign Affairs, shall be fined up to 5,000 pesos or imprisoned up to 5 years.
Notice the penalty. It's the exact same 5-year hammer they drop on fake diplomats.
The state views an unregistered agent as an equivalent threat to national security.
But think about what acting as an agent meant in 1946. It was mostly tangible,
Very much so.
It meant procuring physical supplies, securing office space for an unacknowledged embassy, maybe negotiating physical trade deals on the docks. It was a physical job.
But as the calendar flips forward, the world changes drastically. The Cold War heats up.
Television becomes ubiquitous.
Global communications networks explode, and suddenly the idea of acting as an agent becomes infinitely more complex.
The battleground shifted entirely. The primary threat was no longer just a spy in a fake uniform trying to steal a physical dossier.
The new threat was psychological.
It was the manipulation of domestic policy, the swaying of public opinion, and the covert funding of political narratives.
The foreign agent wasn't stealing secrets anymore. They were trying to change the minds of the citizens.
Which brings us to the Foreign Agents Act of 1979. We are leaving the physical realm of the post-war era and entering the psychological regulations of the information age.
This is the shift from policing uniforms to policing public relations campaigns.
And when you open Batas Pambansa Belong 39, the 1979 Act, the very first thing you encounter in Section 2 is the Declaration of Policy.
It is explicitly clear about its intent. Driven by national security and interest, the goal of the law is to regulate the activities of foreign agents, require them to register, and mandate the disclosure of their political activities.
And I find the justification it gives really fascinating. It says this regulation is necessary so that the government and the people of the Philippines may be informed of their identity and may appraise their statements and actions.
That word appraise is the psychological key to the entire law.
How so?
Well, the state isn't necessarily saying foreigners cannot speak to our citizens. It is saying when a foreigner speaks to our citizens, the citizens must be given the necessary context to judge the motive behind the message.
It is fundamentally an anti-deception mechanism.
Yes. To understand how wide a net this law casts, we have to look at the definitions in Section 3.
Right, because if a law is trying to stop foreign influence, who qualifies as foreign?
It is an incredibly broad definition. A foreign principal can be the government of a foreign country or a foreign political party, which is obvious.
Sure.
But it also includes any foreigner located inside or outside the Philippines. It includes any partnership, association, corporation, organization, or other combination of persons owned or controlled by foreigners.
Let me stop you there, because the implications of that are just massive. It's not just the French government or the CIA.
Not at all.
It could be a multinational oil corporation based in Texas. It could be a wealthy technology billionaire living in Tokyo. It could be an environmental NGO headquartered in Geneva.
If the money or the control is foreign, they are a principal.
Wow. And the law anticipates that these principals aren't going to just walk into Manila and start handing out flyers themselves.
No, they are going to hire locals. That is where the definition of foreign agent comes in.
A foreign agent is any person who acts or agrees to act as a political consultant, public relations counsel, publicity agent, information representative, or just a general attorney or servant for a foreign principal.
And crucially, the law includes anyone acting for a domestic organization that is subsidized directly or indirectly, in whole or in part, by a foreign principal.
This is the shell game provision, isn't it?
Exactly. The drafters of this law were incredibly paranoid, and probably rightfully so.
They knew a foreign intelligence agency wouldn't just wire money directly to a local PR firm.
Right. They would funnel the money through a shell corporation, which donates it to a local domestic charity, which then hires the PR firm to run a political campaign.
And the 1979 law basically says, we don't care how many layers you put between the money and the message. If we can trace the funding back to a foreign source, you are a foreign agent.
It is a sweeping definition. But, the law does have to carve out some common sense exclusions. Otherwise, global society would grind to a halt.
Like what?
Well, it explicitly excludes duly accredited diplomatic or consular officers.
Because they are already covered by the 1946 law and international treaties. We already know who they are.
Exactly. It also excludes officials of the United Nations and other recognized international organizations acting within their legitimate functions.
Okay, that makes sense.
And very importantly, it excludes bona fide members or employees of a foreign press service or news organization, provided they are acting within their legitimate news gathering functions.
I'm glad you highlighted that, because protecting the freedom of the press is vital here.
Absolutely.
If an American journalist is working in Manila for a New York newspaper, they are technically a person working for a foreign corporation, gathering information. But they aren't lobbying. They are observing and reporting.
Right. The law has to draw a firm line to protect journalism from being classified as foreign espionage.
Although, history shows us that the line between legitimate news gathering and state-sponsored propaganda can sometimes get very blurry.
Which is exactly why the law uses the term bona fide. It must be in good faith.
When I was reading through this policy, this idea that the public must know the identity of the agent so they can properly appraise the statement, it immediately made me think of modern social media architecture.
Oh, in what way?
Think about Instagram or YouTube or TikTok today. If a popular influencer posts a video raving about a new skincare product, their audience trusts them.
Right, they have that parasocial relationship.
Exactly. But if that influencer was secretly paid $10,000 by the skincare brand to make that video, it's deceptive marketing. The audience thinks they are getting an organic, unbiased recommendation from a friend, when in reality they are watching a paid commercial.
To combat this, platforms and trade commissions mandate the use of a paid partnership tag or a hashtag ad.
The required disclosure.
Right.
The 1979 Foreign Agents Act is essentially demanding a geopolitical hashtag ad. It is saying, if you are pushing a political idea or advocating for a policy or trying to stir up a public narrative and you are doing it on behalf of a foreign entity, the public has a fundamental right to see the sponsor tag.
The government is terrified that citizens will be duped into thinking a sophisticated foreign-funded PR campaign is actually a spontaneous grassroots domestic movement.
That analogy perfectly encapsulates the psychological shift, I think. The state has realized that ideas and narratives are weapons.
They really are. They can shape domestic policy, alter election outcomes, and destabilize a society just as effectively as an invading army.
Perhaps even more effectively, because the influence is invisible. The citizen doesn't realize their opinions are being engineered.
Which leads us to the most critical question of this entire deep dive.
If these PR councils and consultants are being regulated this heavily, what exactly is the specific activity the government is trying to drag into the light? What are they so afraid of?
To answer that, we have to look at two highly specific and frankly deeply concerning legal definitions in Section 3.
Political activity and political propaganda.
Yes.
The broadness of these definitions blew my mind. Let's look at political activity first.
Go ahead.
The law defines it as any activity which seeks in any reasonable degree to prevail upon, indoctrinate, convert, induce, persuade, or in any other way influence any agency or official of the government or any section of the public regarding domestic or foreign policies or the political or public interest of a foreign government.
I want to focus on the verbs the drafters chose there. Prevail upon, indoctrinate, convert, induce, persuade.
That is what caught my eye. Look at the massive gradation in those words.
It's quite a spectrum.
Indoctrinate sounds incredibly severe. It conjures images of secret compounds and brainwashing. Convert has deep religious or ideological undertones.
So then you slide down the scale to induce. And finally, you arrive at persuade in any reasonable degree.
Persuasion is the absolute bedrock of human communication. Every conversation involves some level of persuasion.
Exactly.
And that is why I have to push back on this definition a little bit. Persuading someone in a reasonable degree regarding a policy could literally mean handing out an informational pamphlet at a bus stop.
Or writing a polite, data-driven op-ed in a local newspaper explaining why a specific foreign investment project would create jobs.
It could mean a trade representative taking a local mayor out to lunch and politely explaining the benefits of a new sister city agreement.
And when you look at the definition of political propaganda, the net gets even wider. It includes any oral, visual, graphic, written, pictorial, or other communication that attempts that same persuasion.
A billboard, a radio advertisement, a printed flyer, a comic book.
But the propaganda definition has a second half, Part B, which takes a very dark, severe turn.
Right.
It includes any communication which advocates, advises, instigates, or promotes social, political, or religious dissension, disorder, civil riot, or conflict involving the use of force or the overthrow of the government.
So on one end of the legal spectrum, you have persuading a mayor about a trade deal. And on the exact same legal spectrum, governed by the exact same law, you have instigating a violent civil riot to overthrow the republic.
It's quite the umbrella.
This is where I am really struggling to see how this works in practice. How can a law ethically or functionally bundle a polite lobbying lunch and an incitement to violent revolution under the identical regulatory umbrella?
The net is infinitely wide.
How do you police something that broad without essentially criminalizing every single conversation a citizen has with a foreigner about current events?
It's a vital question, and it speaks to the core strategy of national security law in the 1970s.
Yeah.
You have to remember the historical context.
1970.
1979 is the heart of a Cold War. The geopolitical landscape is defined by proxy conflicts, covert intelligence operations, and massive state-sponsored disinformation campaigns.
So the broadness of these definitions is not sloppy drafting. It is highly intentional.
You're saying it's a feature, not a bug.
Exactly. By casting a massive, seemingly infinite net over the concept of influence, the government ensures that no foreign actor can exploit a legal loophole.
Think about it. If the law only targeted extreme actions like indoctrination or incitement to riot, a sophisticated foreign PR firm would never get caught.
They would run massive manipulative campaigns, and when questioned, they would just say, "Oh, we aren't indoctrinating anyone. We are merely offering friendly advice."
We are just providing educational pamphlets. They would rebrand their subversion as consultation.
Precisely. They would hide their influence in the gray area of polite persuasion. So the state just eliminates the gray area entirely.
The law defines the roles to cover every possible angle. Section 3 lists a political consultant as someone informing or advising. A public relations counsel is someone representing a principal.
A publicity agent is someone disseminating information. An information representative is someone gathering and publishing data.
They really mapped out the entire supply chain of information, gathering the data, advising on the strategy, representing the client, and publishing the spin.
The state is effectively saying, we don't care what euphemism you use. We don't care if you call it advice, PR, publicity, or data gathering.
If a foreign entity is paying for it and it influences our policies or our public in any reasonable degree, it is political activity, and we want to know about it.
It forces maximum disclosure.
It demands to see the entire iceberg, not just the violent 10% visible above the water, but the massive foundation of polite lunches, strategy memos, and data gathering hidden beneath the surface.
Because the intelligence services know that sometimes the polite lunch is exactly what secures the funding for the inflammatory flyers.
Okay, I see the logic. But because the net is so incredibly wide, if you actually get caught in it, if you take a job that legally classifies you as a foreign agent, the process to legally engage in that activity is staggering.
The government doesn't just grant you a license and say, okay, go ahead and lobby. They bury you alive in paperwork.
Which brings us to the bureaucracy of influence. The registration and public scrutiny requirements in the 1979 Act are monumental. They are designed to be exhausting.
I want to make this tangible for you listening. Let's invent a hypothetical scenario to see how this law actually functions. Let's say I run a local public relations firm called Apex Communications.
Okay, Apex Communications.
A foreign ministry of energy hires Apex to run a campaign convincing the local public that a new foreign-owned power plant is safe and necessary. I am now officially a foreign agent pushing political propaganda. Under Section 4 of this law, what happens on day 1?
The clock starts ticking immediately. Under Section 4, you must register with the Ministry of Justice within 10 days of becoming an agent.
10 days is an incredibly tight window to compile the level of detail the government demands.
And it's not just a web form you click submit on. The registration statement must be under oath. That means if you omit a detail or fudge a number, you are committing perjury.
And the list of required information is exhaustive. I have to provide my name and all business addresses. I have to name the Foreign Ministry of Energy as my principal.
You must also provide a literal physical copy of your employment contract.
What if we didn't sign anything? What if it was a handshake deal?
If you don't have a written contract, you have to provide a full sworn written statement of the exact terms and conditions of that agreement.
Wow. I also have to detail the exact compensation I am receiving and the form of that compensation. And look at paragraph E. I have to list anyone who has even promised to contribute to my compensation.
But the real trap is paragraph G. It requires a detailed statement of every activity which the registrant is performing or is assuming or purporting or has agreed to perform, which requires his registration.
So Apex Communications has to spell out exactly what our campaign strategy is. We're doing radio ads, we are handing out flyers, we are taking local politicians to dinner.
And if Apex is a corporation, you also have to hand over your corporate charter, your articles of incorporation, and your bylaws. The government is demanding a complete operational X-ray of your business.
And that initial registration is just the price of admission. The ongoing maintenance is where the bureaucratic friction really grinds you down.
Section 5 outlines the additional statement. This is the ongoing check-in.
Every 6 months, I have to file a sworn update with the Ministry of Justice. I have to update all my basic facts.
But look at paragraph B of Section 5. You have to detail the extent to which you are supervised, directed, owned, or financed by any foreign principal.
And I must report the nature and amount of contributions, income, money, or things of value I received during the preceding 60 days.
It gets worse. You don't just report what came in, you have to report exactly what went out.
What do you mean?
Paragraph C demands a detailed statement of money and things of value spent or disposed of by the registrant during the preceding 60 days in connection with your activities.
So, twice a year, I am submitting a highly detailed, sworn financial accounting of my lobbying efforts. I have to track every dinner receipt, every printing cost, every radio ad buy, and swear under oath that it is accurate.
And Section 6 makes it very clear that this isn't just going into a dusty archive.
No, these records are active intelligence. The Minister of Justice retains these statements as public records. They are legally open to public examination and inspection at all reasonable hours.
Furthermore, the Minister of Justice is required to transmit copies promptly to the Minister of Foreign Affairs and the Minister of Public Information.
The Justice Department, the Diplomatic Corps, and the public communications arm of the state are all actively tracking my movements. But as intense as that financial tracking is, it is nothing compared to Section 9.
Ah, Section 9. This is the rule regarding the actual propaganda itself.
It is punishing.
It says that if a foreign agent transmits or disseminates any political propaganda for their foreign principal among 2 or more persons, they must, not later than 48 hours after the beginning of the transmittal, file 2 copies of it with the Ministry of Justice.
2 physical copies within 48 hours.
I really want you to visualize the reality of this for your hypothetical PR firm. Let's say Apex Communications prints 5,000 pamphlets about this power plant.
Okay, I hire a team of interns to stand on street corners in the financial district and hand them out to passing commuters on a Tuesday morning at 8 a.m.
A standard grassroots PR tactic.
Under this law, the 48-hour clock starts ticking the second that first intern hands the first pamphlet to a commuter.
Yes.
I have until Thursday morning to physically run down to the Ministry of Justice, hand a bureaucrat 2 physical copies of that exact pamphlet, and provide a sworn document setting forth full information as to the places, times, and extent of such transmittal.
You have to report exactly what street corners your interns stood on, what hours they were there, and exactly how many pamphlets they gave away.
And I have to do this for every single piece of propaganda I generate. Every press release, every poster, every radio script.
Every single one.
Isn't this an absolute administrative nightmare? If I am running a dynamic, fast-paced political campaign, I would have to hire an entire Department of Compliance officers just to sprint back and forth to the Ministry of Justice every 2 days to file paperwork.
How could any PR firm function efficiently under this level of micromanagement?
Exactly.
They can't function efficiently. That is the genius of the law. You are looking at it as a bureaucratic nightmare, and the national security officials who drafted it would smile and say, yes, exactly.
Friction is the point.
The bureaucracy is the barrier. By demanding detailed financial accounting every 6 months and requiring 2 physical copies of all materials within 48 hours, along with precise geographic distribution data, the government makes shadow lobbying exhausting, expensive, and legally perilous.
They aren't explicitly violating free speech by banning the pamphlet. They are just making the act of distributing the pamphlet so administratively agonizing that you have to be completely committed, highly funded, and entirely transparent to pull it off.
Transparency is achieved through rigorous, relentless paperwork. If a foreign entity wants to influence domestic policy, they have to be willing to leave a massive, highly visible, constantly updated paper trail.
And if they slip up, if my intern forgets to file that pamphlet by Thursday morning, or if I miss a dinner receipt on my 60-day financial update, I'm not just facing a late fee. I am suddenly committing a crime.
It is a trap made of filing cabinets and sworn oaths. But, to be fair, the law recognizes that a modern nation has to engage in global trade and cultural exchange.
You can't treat every importer or guest lecturer like a covert spy.
Which leads us to Section 7, the exemptions. This section carves out specific areas where you do not have to register as a foreign agent, even if you are technically working for a foreign principal.
The first exemption is for engaging only in private and non-political activities in furtherance of bona fide trade or commerce.
If you are a local distributor for a foreign car manufacturer, you are an agent for a foreign corporation, but you are just selling cars.
It's commerce, it's non-political, so you are exempt from the 48-hour pamphlet rules.
Second, the law exempts activities in furtherance of bona fide charitable, religious, scholastic, academic, artistic, or scientific pursuits.
This one feels a little squishy to me. Artistic or scientific pursuits. What if a foreign government secretly funds a highly biased documentary film about a territorial dispute and calls it an artistic pursuit?
Or what if a foreign oil conglomerate funds a deeply flawed scientific study designed to cast doubt on climate change regulations? Who decides what is bona fide?
That is the eternal tension in foreign influence laws. The term bona fide literally means in good faith, but good faith is subjective.
Ultimately, the Ministry of Justice and potentially the courts would have to look at the funding, the intent, and the distribution of that documentary or study to determine if it is genuine art and science or if it is political propaganda masquerading as such.
It requires human judgment. But the exemption has to exist. Otherwise, every foreign guest lecturer at a university or every international art exhibit would trigger national security registrations.
Okay, I can see the necessity, even if it creates a gray area. The third major exemption is for the legal representation of a foreign principal before any court or government agency.
If a foreign corporation is sued in a local court, they need a local lawyer to defend them. That lawyer shouldn't have to register as a political agent just to file a motion to dismiss.
However, the drafters anticipated how this could be abused, so they added a crucial, massive caveat to this legal exemption. The law explicitly states that for the purposes of this subsection, legal representation does not include attempts to influence or persuade government personnel or officials other than in the course of their ordinary official business.
So a lawyer cannot secretly act as a political lobbyist under the guise of attorney-client privilege.
You can defend the foreign company in front of a judge in a courtroom, but the moment you take a senator out to a private dinner to influence or persuade them about a pending regulatory bill, you can't claim, oh, I'm exempt because I'm their lawyer.
Exactly. The moment the lawyer steps out of the courtroom and into the realm of political persuasion, the legal shield evaporates. The lawyer becomes a foreign agent and must start filing paperwork.
It's a massive loophole closer. And speaking of closing loopholes, while Section 7 gives us the exemptions, Section 11 drops the hammer with the absolute prohibitions.
These are the unlawful acts. These are things that no amount of paperwork, no registration, no 48-hour filings can ever excuse. If you are a foreign agent, these actions are strictly, universally forbidden.
Section 11, paragraph 1A, is the anti-deception rule in practice. It makes it unlawful to transmit political propaganda to any government agency or official, or to request information or advice from them, unless the propaganda or request is prefaced or accompanied by a true and accurate statement that you are registered as a foreign agent.
This goes back to the social media analogy.
Yeah.
You can't just slide a policy paper across a bureaucrat's desk and pretend you wrote it as a concerned, patriotic citizen.
You have to effectively announce, hi, I'm handing you this document on behalf of my client, a foreign government.
You have to declare the hashtag #AdTag in person.
And then we get to paragraph 1B, which is one of the most structurally fascinating prohibitions in the law. It bans contingency contracts.
It is unlawful to have a contract with a foreign principal where your payment is contingent, in whole or in part, upon the success of your political activity.
You cannot agree to a success fee for lobbying.
And I really need to zero in on this one, because I have some major pushback here. Why is a contingency contract illegal in this context?
I know it sounds restrictive.
Think about how the legal world works. Personal injury lawyers do no win, no fee all the time. Real estate agents work on commission. They only get paid if the house sells.
It aligns the agent's incentives perfectly with the client's goals.
Right. Why is it suddenly a criminal act just because the client is a foreign entity?
You have to look at what that alignment of incentives actually produces. In a personal injury case, a contingency fee helps the little guy access justice.
Because a person who is injured by a massive corporation can't afford a lawyer at $500 an hour.
So the lawyer takes the financial risk in exchange for a cut of the settlement. It democratizes the legal system.
Right. So wouldn't a contingency fee help a poorly funded foreign NGO lobby for human rights or environmental protections?
Yeah.
If you ban contingency fees, don't you just hand a massive advantage to wealthy foreign corporations who can afford to pay expensive PR firms a massive hourly retainer regardless of success?
That is a very compelling argument regarding equity, but you have to view this through the lens of national security, not just market fairness.
Okay, explain that.
In geopolitics and domestic policy, the goal isn't accessing justice for a wronged individual. The goal is altering the laws of a sovereign nation. If you allow a foreign agent to operate on a contingency fee, meaning they only get their $1 million payout if they successfully block a specific tariff or successfully pass a specific mining regulation, you create a dangerously perverse incentive.
I'm trying to see the danger.
A contingency fee creates desperation. It incentivizes the foreign agent to use any means necessary to achieve that political outcome because their entire livelihood depends on that specific legislative result.
Oh, I see.
If a lobbyist is getting paid hourly, they can advocate legally, shrug if they lose the vote, and still pay their rent. But if they only get paid upon success and the deadline is approaching, the temptation to cross the line from legal persuasion into illegal bribery, blackmail, extortion, or other corrupt practices skyrockets.
The state bans contingency contracts to prevent foreign principals from weaponizing the financial desperation of their local agents. Wow. That makes complete sense. You are removing the financial incentive for corruption. You can be paid for your time, you can be paid for your effort, but you absolutely cannot be paid for the legislative result.
You cannot put a bounty on a domestic law.
Okay, what else is explicitly banned?
Paragraph 1C makes it unlawful to make or promise to make any contribution of money or anything of value in connection with any convention, caucus, or process to select candidates for political office.
No foreign money in domestic elections. That is a foundational rule for almost any democracy.
And paragraph 2 makes it just as illegal for any person in the Philippines to solicit or accept those contributions from a foreign agent.
Finally, paragraph 3 of section 11 states that it is unlawful for any public officer or employee or their spouse to act as a foreign agent.
You cannot serve two masters. You cannot draw a salary from the Philippine government and simultaneously be a registered, paid agent for a foreign government.
That seems like an obvious conflict of interest.
But again, the law is highly practical. It includes a caveat for exceptional circumstances. The government can employ a foreign agent, provided that the head of the employing agency certifies that such employment is required in the national interest.
So if a specific individual has unparalleled, highly specialized expertise, maybe in nuclear energy or international trade law, and they happen to also represent a foreign entity, the government can still hire them.
But it requires a high-level public certification that is then filed with the Minister of Justice. Everything comes back to transparency and the paper trail.
So we've walked through the massive bureaucratic hurdles of registration. We've seen the absolute prohibitions on contingency fees and election funding. The logical final step in this legal journey is, what happens when someone decides to ignore all of this?
What happens if our hypothetical PR firm hides a contingency contract, or fails to file their 60-day financial update, or just refuses to register altogether?
The government drops the hammer. And they do it in a way that is designed to be swift and devastating to the operation. This brings us to the enforcement mechanisms. Injunctions, penalties, and what I like to call piercing the corporate veil.
Let's start with the administrative level of enforcement. Under Section 8, the Minister of Justice doesn't have to wait for a massive crime to occur.
Right.
If the minister looks at a registration statement and decides it is deficient, maybe the language is too vague, or it's missing the exact terms of the employment contract, the minister notifies the agent in writing.
And the moment that notification is received, it becomes unlawful for that person to act as a foreign agent until they file an amended, fully compliant statement.
That is immense administrative power. The minister can just flip a switch and legally freeze your operations. Your PR firm is grounded until your paperwork is perfect.
If you keep operating anyway, or if the minister believes you're about to violate the act, Section 10 gives the government massive judicial power.
The minister can go to court and secure a temporary or permanent injunction or restraining order against you.
And the law explicitly states, the proceedings shall enjoy the highest priority and shall be expedited in every way.
They aren't going to let a foreign propaganda campaign drag out in court for years while the damage is being done to the public discourse. The courts are ordered to fast-track these injunctions to stop the bleeding immediately.
But the injunction is just the tool to stop the activity. The punishment for the activity itself is found in Section 12, the penalties.
This is where the stakes get very real.
If you violate any provision of the Act or fail to file a required statement or make a false statement of material fact, you are liable on conviction to imprisonment for a term not exceeding 5 years or a fine not exceeding 10,000 pesos, or both.
And there is that 5-year penalty again.
But here's the part of Section 12 that genuinely shocked me. It's the second paragraph.
Yes.
Let me read it exactly. If the offense is committed by a corporation, partnership, association, or any other organization or entity, the penalty provided herein shall be imposed on the president, managing director, managing partner, or chief operating officer, whichever the case may be.
The corporate guillotine.
I really want to emphasize why this is so radical. In typical corporate law, the corporation itself is treated as a separate legal entity. That is the entire point of incorporating.
If a massive PR firm screws up a regulatory filing, the firm gets fined. Maybe the firm loses its license. Maybe some low-level compliance manager gets fired.
But the CEO sitting in the corner office rarely faces personal criminal liability unless the state can prove they specifically ordered the illegal act.
The corporate shield usually protects the executives.
Right. But this law pierces the CEO shield entirely. It imposes strict liability on the executive leadership.
A corporate president cannot blame a rogue PR intern for failing to register a foreign contract. The president cannot go to court and say, "I'm the CEO, I didn't know my team missed the 48-hour filing deadline for that pamphlet."
The law says, if your organization violates this act, you, the president, managing director, or chief operating officer, take the penalty. You go to prison for up to 5 years.
It is a remarkable piece of legislative design, and it speaks to how seriously the state takes foreign influence.
By holding the very top of the corporate hierarchy personally and criminally liable, the state ensures that compliance with the Foreign Agents Act is never just a secondary task delegated to the legal department.
It becomes a primary existential priority for the CEO. When 5 years of your own freedom is on the line, you're going to make absolutely certain that your firm tracks every penny and files every single pamphlet within 48 hours.
It guarantees top-down compliance. And the section adds one final decisive note. If the offender is a foreigner, after they pay the fine and serve their prison sentence, they are subject to immediate deportation.
Which perfectly ties the thematic thread all the way back to where we started this deep dive with Republic Act 75 from 1946.
Let's trace that thread.
Think about the penalties we've discussed across these two eras. In 1946, if you put on a fake suit and pretend to be a foreign diplomat to extract secrets or money from the government, the penalty is 5 years in prison.
Also in 1946, if you act as an unregistered physical agent for a foreign government, the penalty is 5 years in prison.
And here, in 1979, 33 years later, in a completely different era, defined by mass media and complex PR campaigns, if you fail to register your political propaganda, the penalty remains exactly the same, 5 years in prison.
That is a remarkably consistent, multi-generational legal stance.
It shows that despite the changing methods, from physical imposters in the 40s to invisible corporate lobbyists in the 70s, the state views the underlying threat as equally severe.
Foreign interference, whether by wearing a fake uniform to bypass a guard or running a hidden PR campaign to bypass the critical thinking of the public, is a direct assault on national sovereignty.
The methods of policing it evolved from physical arrests to bureaucratic filing systems, but the boundary, the 5-year wall, remained rock solid.
That is an incredible way to view it. We really have spent this deep dive exploring how a nation legally constructs boundaries around influence.
We started our journey looking at literal physical boundaries, protecting ambassadors from physical arrests, voiding warrants, and punishing imposters who try to breach the gates of diplomacy with fake credentials.
And then we moved into the psychological boundaries, creating massive bureaucratic hurdles to expose foreign-funded public relations, propaganda, and lobbying.
The state realized it couldn't arrest an idea, so it forced the invisible influencers to leave a highly visible paper trail.
And we are sharing all of this with you, the listener, because these laws are not just historical curiosities from the 40s and 70s. They matter deeply to the world you live in right now.
These laws are a stark reminder that the information you consume every day, the political arguments you hear debated on television, and the policies that your local officials enact are very often shaped by invisible hands.
By understanding the immense lengths to which a government must go to try and regulate these foreign agents, the 48-hour rules, the CEO liabilities, the absolute ban on contingency fees, you become a much more critical consumer of information.
You start looking for the hidden sponsor tags and the political narratives around you. You stop taking the pamphlet at face value and start asking who paid for the printing press.
Because the battle for influence didn't end in 1979. In fact, the technology of influence has only accelerated. And that leaves us with a final provocative thought to consider.
Let's hear it.
We spent a lot of time discussing Section 9 of the 1979 law. That is the rule meticulously demanding that foreign agents submit 2 physical copies of their visual or pictorial propaganda to the Ministry of Justice within 48 hours of handing them out, detailing exactly where and when they were transmitted.
It was a system built for a world of printing presses, interns on street corners, and filing cabinets.
But as you navigate the modern digital world today, consider this. How would a government even begin to apply these exact same principles to a decentralized, borderless algorithm?
How do you demand 2 physical copies within 48 hours when the foreign propaganda is being generated by anonymous AI bot farms, targeted to millions of individual smartphones with personalized messaging, and then deleted in a matter of seconds?
The fortress walls have never been harder to build because the invaders don't even have to cross the border.
The invisible battlefield is everywhere.
And that is something worth thinking about the next time you scroll through your feed. Thank you so much for joining us on this deep dive into the legal architecture of influence. We hope you walk away seeing the world and the information in it just a little bit differently. Until next time, stay curious.
Welcome to the debate. Imagine you're a researcher studying poverty in Manila. You're a local citizen, you work for a local organization, but your team just received a small grant from an international NGO to help fund your data collection.
Right, a pretty standard scenario for academic research.
Exactly. But suddenly, you receive a legal notice. Under the law, because of that partial, indirect international funding, you are now classified as a foreign agent.
Oh, wow.
Yeah. You have to surrender your financial records, swear an oath to the government, and if any article you publish is deemed to promote social dissension, well, you could land in prison.
It honestly sounds like a dystopian novel. But it is actually the mechanical reality of how certain foreign influence laws operate on the ground.
It really is.
When a state decides it needs to protect itself from outside interference, the legal architecture it builds can very quickly turn inward. The defense mechanism meant to guard the border becomes this net that catches the state's own citizens.
And that tension, balancing a sovereign nation's absolute need to defend itself against covert foreign influence with the risk of over-regulating its own civil society, is exactly what we are digging into today. We're looking at 2 foundational pieces of Philippine legislation. First, the Protection of Foreign Diplomatic and Consular Agents Act of 1946.
Which was passed right after the Philippines gained independence following World War II, right?
Correct. And second, the Foreign Agents Act of 1979, known locally as Batas Pambansa Blig 39. That literally translates to National Law 39, and it was enacted during the martial law era of Ferdinand Marcos.
Looking at these 2 laws side by side is really a masterclass in how statecraft evolves. The 1946 law is fundamentally about setting up the basic rules of international diplomacy for a newly independent nation.
Yeah, laying the groundwork.
But by the time we get to the 1979 law, the whole philosophy has shifted entirely. We move from protecting actual accredited diplomats to creating this massive bureaucratic surveillance system aimed at domestic actors.
Which brings us to the central disagreement we are exploring today. Are these laws primarily essential, targeted transparency mechanisms designed to protect national sovereignty?
Or do they construct an overly broad regulatory net that inherently suppresses and criminalizes legitimate public discourse?
Right. And I take the position that these acts, while tough, are absolutely vital transparency measures. They are designed to protect the domestic political process from undisclosed shadow influence.
And I argue that the 1979 law, in particular, relies on incredibly sweeping definitions. It doesn't just regulate the source of funding, it regulates the actual content of speech.
So you see it as a domestic control issue.
Exactly. Ultimately, it creates an architecture of domestic control, not just foreign transparency.
Well, to understand this tension, you really have to look at what governments actually claim they are doing when they pass these laws and why they feel compelled to do it. Think about the post-World War II context of the 1946 Act.
Sure, the immediate post-war era.
You have a newly independent Philippines trying to establish itself on the global stage. It needs foreign nations to send ambassadors, and to do that, it has to guarantee their safety.
Makes sense.
So the law establishes severe penalties. We're talking up to a 3-year prison sentence for anyone, even a domestic judge or police officer, who unlawfully arrests or sues a legitimately accredited ambassador. The state is actively policing its own officials to protect genuine, open diplomatic relations.
I come at it from a different way. I actually agree that the 1946 Act is a reasonable post-war effort to establish diplomatic norms. It's about protecting people who carry diplomatic passports.
Right, we agree on that baseline.
But you cannot use the noble intentions of 1946 to shield the realities of 1979. To understand the 1979 Act, you really have to look at the operative mechanics, specifically the definitions.
Go on.
When you look at how it defines a foreign principal, the scope is just staggering. It isn't just a foreign government or a foreign political party. It explicitly includes any domestic organization subsidized indirectly, in whole or in part, by a foreign principal.
Which, to me, is just a necessary recognition of how modern funding works. I mean, money is fungible. If a foreign government wants to influence local politics, they aren't going to just wire money directly to a local politician's bank account.
Well, they might try, but
But usually, they're going to route it through a seemingly independent think tank or a shell NGO. The law has to cast a wide net on the funding side to catch the actual influence.
But indirectly, in whole or in part, means a completely domestic grassroots civic organization that receives a fractional grant from an international body is now legally tethered to the definition of a foreign principal, say from the UN or a global health fund. That is a massive leap.
It's a broad definition, sure.
And it gets exponentially worse when you look at how the law defines political propaganda. It includes any communication that, and this is a quote, advocates, advises, instigates, or promotes social, political, or religious dissension.
Wait, let me make sure I'm following you here. Are you saying the law actually explicitly names religious disagreements as a trigger for foreign propaganda?
It really does. Let that sink in. Advocating religious dissension is classified as foreign political propaganda.
Because reading it at face value, that sounds wildly unconstitutional, or at least a massive overreach.
It explicitly names it. It classifies promoting religious or social dissension as political propaganda if there is that indirect fractional foreign funding tied to the speaker.
That is definitely a strict reading of the text.
This broad language transforms what you call a transparency mechanism into a chilling mechanism. It allows the state to look at domestic religious debates or social protests, trace a tiny fraction of indirect international funding, and label the whole thing as foreign subversion.
I see why you think that, but let me give you a different perspective. We have to acknowledge that foreign influence in the modern era is inherently multifaceted.
True.
It does not arrive wearing a uniform and carrying a flag. It arrives through public relations firms, policy consultants, and media strategists. The 1979 Act is structurally rigorous because the threat it is fighting is rigorous.
Rigorous is one word for it.
Well, the law deliberately breaks down the concept of a foreign agent into precise categories. It lists political consultant, public relations counsel, and information representative. Let me offer an analogy here. Think about consumer protection laws. When you buy a...
Hold on. I need to stop you right there. I know where you're going with the consumer protection analogy, like labeling ingredients on a box of cereal.
Exactly, the ingredients label.
But regulating physical ingredients in a consumable good is fundamentally different from regulating an information representative. Human speech and intellectual inquiry are not a box of cereal.
But the mechanism of transparency is the same. A consumer has a fundamental right to know the precise ingredients of a product to evaluate its safety and nutritional value.
Right, but
in a sovereign democracy, the public has the exact same right regarding the marketplace of ideas. We need to know the precise origin, funding, and intent of political messaging to evaluate its credibility.
I hear the appeal of that argument. I really do.
If a public relations counsel is injecting messaging into the domestic policy sphere on behalf of a foreign entity, the public must know the ingredients of that message. If you don't know who is paying the PR firm, you can't properly appraise the information.
But that argument completely collapses when you look at how the law actually defines an information representative. It isn't just targeting high-powered lobbying firms in tailored suits.
Who else is it targeting?
The law defines an information representative as anyone who engages in collecting or gathering data and in disseminating or publishing the same. That is not a targeted regulation of a PR firm.
It's broad, yes.
That is a dragnet over basic academic research, sociology, and journalism. Think back to that researcher scenario we started with. If they gather data on poverty and publish it, and their NGO got a partial international grant,
Then they have to register.
boom, they are a foreign agent publishing propaganda. A consumer protection law doesn't throw you in jail for advocating a different recipe. This law criminalizes the act of promoting social dissent.
But you are isolating the definitions from the exemptions. The law is not a blind dragnet. It is highly targeted, and it explicitly protects the exact people you're worried about.
Does it, though?
Yes. If you look further into the 1979 Act, it explicitly states that the regulations do not apply to persons engaging in private, non-political activities. It expressly exempts activities in furtherance of bona fide trade.
Okay, but what about the researchers?
It specifically lists scholastic, academic, artistic, or scientific pursuits, so the researcher is protected. The religious advocate is protected.
Assuming the state categorizes their pursuit as bona fide and non-political. And who gets to define those terms? The state.
Well, the legal text provides the shield. And even for those who do qualify as foreign agents, let's look at the actual burden placed on them.
It's a massive burden.
The law outlines the requirement for filing and labeling political propaganda. What is this terrible burden you're talking about? A foreign agent simply has to, within 48 hours of transmission, file 2 copies of the propaganda with the Ministry of Justice. That's it.
That's just one piece of it.
It's a minor administrative burden for the sake of the public record. It doesn't say you cannot publish this. It simply says you must file a copy.
Calling it a minor administrative burden vastly understates the reality of compliance under this act.
In an era where disinformation moves at lightning speed, a 48-hour filing requirement is a perfectly calibrated response to ensure transparency without prior restraint.
You are focusing on the propaganda filing, but let us look at the grueling bureaucratic machinery established for registration. Now, if you're listening to this, you might be thinking, okay, registering with the government isn't a big deal.
Right, we register for everything.
But autocratic regimes don't always need to make speech illegal. They just make it bureaucratically impossible.
Explain what you mean by that. How is a registration form weaponized?
It's the concept of lawfare. The bureaucracy itself is the punishment. Under this law, you have exactly 10 days to register after becoming an agent.
That seems like a reasonable window.
You have to do it under oath. You have to hand over every contract of employment. You have to provide a detailed statement of every activity you are performing, even the activities you are doing that have nothing to do with the foreign principle.
Well, that requires a holistic view of the agent's operations, right? Just to ensure the foreign influence isn't being masked by their other, seemingly benign activities.
It requires completely surrendering your organizational privacy. And it doesn't stop there. Every 6 months, you have to file an updated sworn statement.
A routine audit.
You have to provide a detailed accounting of all money received and spent in the preceding 60 days. This is an exhausting, continuous audit of a person's or an NGO's entire professional and financial life.
But if they are receiving foreign money, they should be accountable.
And here is the fatal flaw regarding your reliance on the academic and religious exemptions. There is a catch-all clause in the law. The registrant must provide such other statements, information, or documents as the Ministry of Justice may from time to time require.
But there's a world of difference between a sweeping conspiracy and standard statutory language. That is just boilerplate administrative flexibility.
It is a blank check. It creates arbitrary enforcement power. When the Ministry of Justice can demand any document from time to time, the supposed protections of the academic exemptions completely evaporate.
I think you're assuming the worst-case scenario.
The state can simply use the administrative burden itself to exhaust and bankrupt any domestic organization it deems problematic. They just bury you in audits under the guise of investigating your indirect foreign subsidies.
I'm not convinced by that line of reasoning because it assumes total bad faith on the part of the judiciary and the ministry, rather than looking at the ultimate consequences the law is actually trying to prevent.
The consequences are severe, though.
Think about why this strict financial accounting is necessary. You have to look at the absolute prohibitions in the law. For instance, the 1979 Act makes it unlawful for a foreign agent's compensation to be contingent on the success of any political activity.
Meaning they ban success fees for political lobbying.
Precisely. And let's explain why that matters. If a foreign agent only gets paid if a specific law passes or if a specific policy is killed, they are essentially incentivized to corrupt the domestic political process at any cost to get their payday.
That is definitely a valid concern.
The law bans that outright. Furthermore, it makes it explicitly unlawful to make, directly or indirectly, any contribution of money in connection with any convention, caucus, or process to select candidates for political office.
And I agree with that part.
These are not minor theoretical concerns. The prohibition on foreign campaign contributions is an absolute necessity to prevent the hijacking of a democracy. These laws are about maintaining a perimeter of sovereignty.
I entirely agree that stopping foreign campaign contributions is a universally valid goal. No democracy can survive if its elections are bought by outside powers.
Right. And we see this philosophy of defending the sovereign perimeter echoed back in the 1946 Act. It establishes the principle of reciprocity.
The diplomatic reciprocity, yes.
Yes, the Philippines will grant robust protections to foreign diplomats, protecting them from arrest, protecting their property, but only if the foreign country provides similar protections to Philippine diplomats. It's a baseline of fairness.
That makes sense in an international relations context.
Exactly. The entire legal framework from 1946 to 1979 is rooted in establishing fair, reciprocal, and transparent sovereign boundaries.
That's a compelling argument, but have you considered the glaring double standard embedded within the 1979 framework? You point to the prohibitions on campaign contributions to show how the act prevents corruption.
Which it does.
But let's read further down in that same section. It states it shall be unlawful for any public officer or employee or his spouse to act as a foreign agent. Excellent, right? We want our public officials loyal to the domestic constituency.
Exactly. It prevents a conflict of interest at the highest levels of public service.
But the law doesn't stop there. It continues. However, the government may employ any foreign agent, provided that the head of the employing agency certifies that such employment is required in the national interest. Do you see the contradiction there?
Honestly, I don't see a contradiction. I see a provision for executive flexibility.
I see a monopoly on influence. Think about the mechanics of this. The law painstakingly defines political propaganda, including social and religious dissension, as a dangerous contagion.
Well, it's a transparency measure.
It says this influence must be rigorously tracked, audited, and restricted under threat of up to 5 years in prison and deportation for foreigners. Yet, the government explicitly grants itself the power to employ these exact same foreign agents to engage in this exact same political activity.
But that's if it's in the national interest.
Right, so long as an agency head deems it in the national interest. This proves the law, especially in the context of a martial law era, is less about the inherent danger of foreign influence and entirely about the ruling government monopolizing who gets to wield that influence. It is a tool to disarm civil society while leaving the state's arsenal fully stocked.
No, that fundamentally misreads the nature of statecraft. There is a vast difference between state-sanctioned diplomatic engagement and undisclosed private subversion.
Is there?
Yes. When the government employs a foreign agent, the law dictates that the agency head's certification must be forwarded to the Minister of Justice and filed publicly along with the registration statement. The state is acting transparently as the state.
But it's still foreign influence.
Governments will inevitably need to hire foreign consultants, whether it's for complex trade negotiations, international legal disputes, or public diplomacy campaigns overseas. Permitting the elected government to do so transparently while forbidding private entities from operating as shadow conduits is not a double standard. It is the very definition of sovereign governance.
But transparently is doing a lot of heavy lifting there, especially when the state completely controls the apparatus of transparency. You keep emphasizing the public record, but when the penalties for non-compliance are 5 years in prison, the chilling effect on domestic organizations who receive any international support is profound.
It enforces compliance.
We have covered substantial ground today, and it's clear this is a deeply complex issue. As we conclude, I maintain my view that the 1946 and 1979 Acts, when viewed together, form a rigorous and necessary legal framework.
They are certainly rigorous.
They demand transparency, they protect accredited diplomats through reciprocal agreements, and they actively shield the domestic political process from undisclosed privately funded foreign interference. By requiring registration, banning success fees, and mandating the filing of political propaganda, the law ensures the public can properly appraise the information they consume.
That's your core takeaway, then? It is. It's about protecting the integrity of the sovereign state from forces that operate in the shadows.
And while I absolutely agree that transparency is a valid and necessary goal, particularly regarding campaign finance, my view remains that the specific mechanisms in the 1979 Act go far beyond transparency.
Because of the scope.
Yes, the sweeping definitions of what constitutes a foreign principle, the inclusion of religious and social dissension as political propaganda, and the heavy bureaucratic burdens of continuous sworn audits create a chilling regulatory net. Furthermore, the government-granted exceptions reveal a system designed to restrict the free exchange of ideas in civil society while preserving the state's ability to utilize those same channels of influence for itself.
Yet, despite our profound disagreements on the implementation and the potential for overreach, there is a clear area of convergence here. We both recognize the absolute necessity for a sovereign state to protect its electoral processes from covert foreign financing.
Completely agree on that.
And we both recognize the enduring wisdom of the 1946 Act in fiercely protecting actual, accredited diplomatic channels. The lasting point of contention between us is whether the specific, granular mechanics of the 1979 Act, the audits, the definitions, the catch-all clauses, cross the line from necessary disclosure into an arbitrary tool that can be weaponized.
Precisely. Analyzing these historical legal texts reveals an enduring, seemingly unsolvable tension between the imperative of national security and the fundamental right to free expression. Every clause we debated today shows how the precise wording of statutes dictates the shape of a society.
It's all in the details.
It is never just about the broad policy goals. It is about the mechanics of enforcement.
There is certainly much more to explore in these materials regarding how governments continuously attempt to define, defend, and sometimes exploit their sovereignty. A society must identify what crosses its borders and who is influencing its debates.
Absolutely.
But as we've seen, the true test of a nation's legal framework isn't just in how fiercely it tracks foreign elements, but in whether it can do so without suffocating the vitality of its own civil society in the process. We leave that judgment up to you.